Well, good morning or good afternoon or good evening to anyone who's joining from wherever you may be. We have a pretty full presentation today, so I'll just get right into it. If you've been following along, this is the last of our Intersections Bankruptcy series. This is the intersections of bankruptcy and environmental law. It's episode 3 of the Financial Poise Bankruptcy Intersection series. You can read more about financial poise on slide 2. Our panelists today are Laura Cordes, professor at Sandra Day O'Connor School of Law at the Arizona State University. I put a "the" in front of it just for you today, Laura. Robert Richards at Denton's LLP, Denton's US LLP, and Jeffrey Schwartz of Much Shellist PC. My name is Anthony Callie. I'm with the law firm of Stinson LLP. You can see our names on slide 6, and you can read our bios on slides 48 through 51. We don't intend this to be an infomercial, so you don't have to listen to me read bios. If you want information about us, look at our bio slides and click on the links therein. About the slides, I'll try to call your attention to slides that are relevant to whatever we're talking about so that you can take notes or follow along if you'd like. But if you are listening and not watching the presentation, you'll be fine. The slides are not critical, and then they will be publicly available. Thank you to our co-producers, the National Law Review. You can read more about the National Law Review on slide 4. Financial Poise webinars are supported in part by our sponsors. This webinar is sponsored by Max Asset. More information on Max Asset is on slide 3. And the last thing before we begin, on slide 5, there is a disclaimer. You are not our clients. We are not your lawyers. What we do here today is for your general education and not for you to act on without appropriate legal advice. All right, all that intro stuff being over with, we can now dive into the intersections of bankruptcy and environmental law. I'm going to start with very broad strokes and set the stage for our discussion. Robert, can you start us off and let us know what some of the key policies that underlie bankruptcy law and environmental law are?
Sure. So bankruptcy is generally a collective action. The goal is generally in Chapter 11, which is what we deal with the most, to try to either reorganize the existing entity or sell it as a going concern, or otherwise, at least do an orderly liquidation and try to have a reorganization of some nature. Sometimes you will see for businesses a Chapter 7 liquidation as well. And another goal of bankruptcy is to generally have similarly situated creditors have similar recoveries. Those can be in conflict with environmental goals. Environmental goals are designed to protect human health and environment, and generally to have the polluter pay for the burden of cleanup costs. As we'll discuss a little later, sometimes there's multiple polluters, which can make that a little more complex.
So Jeffrey, Robert set that up, but it seems that these two areas of law are set up for conflict, or at least they're ripe for conflict. Are they indeed at odds with one another, and what can people in this sphere do to harmonize their goals?
Well, they're not completely at odds. I mean, there is a baseline that, just because you're in bankruptcy doesn't mean you can ignore laws. I mean, you can't not pay minimum wage. You can't go murder someone. So, I mean, you're still, there's certain things that are covered by the automatic stay, but, it doesn't mean you can just ignore laws just because you're in bankruptcy. So, there are courts that are sympathetic because it's often the properties in their community to, cleaning up the property as well. So as we'll get into the case law a little later in detail, there tends to be a balancing of the, of the two concerns, and especially if it's a reorganization and the environmental problem has not been entirely addressed, it's going to be an ongoing issue, and that needs to be addressed as part of the exit from bankruptcy.
Jeffrey, do you have anything to add to that?
Yeah, I would just say, I think you're right, and Bob, as you and Bob point out, there's definitely this inherent conflict. I think it was Judge Gerber out of the Southern District of Illinois who said in one of his opinions, issues as to the interplay between environmental law and bankruptcy law are among the thorniest on the litigation map. And, if a debtor could file bankruptcy to get out of its environmental liabilities, just basically every manufacturing company out there would, if they could, file for bankruptcy to get out of those. So there's got to be some give and take there. Obviously, a debtor, wants to reduce its liabilities and doesn't want these obligations on a go-forward basis, and that's got to be weighed against the goals of the environmental about a polluter. Someone's got to clean it up, and it can't just be left to the government. Courts are all over the place, and I think that's a good thing, because that gives flexibility. I think just like in any bankruptcy case, the interplay between environmental laws and bankruptcy laws lead to consensus and lead to, a resolution. And that resolution kind of makes things come out, I wouldn't say evenly, but more just, where one policy is not completely overtaking the other policy. It's one of the questions on the slide is, will strict enforcement of environmental laws jeopardize efficient reorganizations? What I see in my cases is that usually the EPA and the DOJ and the state regulatory agencies that are in there, they're in there and they know what they're doing, and they're enforcing their rights pretty strongly. But I also think that with the ambiguity in the case law and the differences in the case law throughout the country, they understand that. They also understand that they can't get everything right. If a debtor doesn't reorganize, it's going to go under, and they're going to be left holding the bag. So I see that this really helps for parties to come to a compromise and to look at the worst case scenario. I'll turn it back to you, Anthony.
Thank you. This is why the bankruptcy bar is so friendly, because we have to have this give and take, or else it just doesn't function. So we're just much friendlier than other lawyers, especially litigators. Laura, can you continue with some of the stage setting and tell us who the main actors are in both the bankruptcy and environmental fields?
Yeah, absolutely. So on the bankruptcy side, we have the debtor and its creditors as kind of two very key players. For those who may not be totally familiar with bankruptcy, the debtor is kind of the main part of the bankruptcy case. Usually it's the party that's filed for bankruptcy relief in a voluntary case. Debtors can be a wide variety of entities, individuals, businesses, municipalities. On the creditor side, we're looking here at creditors that hold a pre-petition claim against the debtor, so a claim arising before the bankruptcy was filed. And we'll get into this a little bit more later, but the timing of a claim is often really important in cases with environmental issues. So creditors can be entities like lenders or trade creditors, but again, thinking more specifically about the environmental context, they might also include, for example, tort claimants, so people who have been harmed in some way by the debtor's activities, or owners of land that's adjacent to the debtor's property. So if, for example, the debtor has been polluting or contaminating water or land, if that contamination has spread beyond its property lines. And then other key players, I think, that are, maybe more specific to environmental issues, although not exclusively. Other key players might be various governmental agencies, state and federal agencies that might either be doing cleanup work or trying to assess whether cleanup work is needed. And then we also have, in the environmental context, what's called potentially responsible parties, or you'll sometimes hear them or see them referred to as PRPs. That's a term from environmental law that encompasses other parties that might be liable under those environmental laws for cleanup costs.
We'll get back to some of those environmental laws in a little while. But before we do that, let's turn it over to you, Jeffrey. And let's say I've got a company that owns a piece of land, and we've got some environmental concerns, and I'm contemplating a bankruptcy. What are some of the things that I need to consider before going into bankruptcy?
Anthony, I'll break it up into two things. One, what the bankruptcy forms require you to disclose, and two, things that you should consider before you go in. And just on the bankruptcy forms, the environmental liabilities are so important. There's actually a specific section of the Statement of Financial Affairs, Part 12, that requires disclosure of environmental liabilities. And that deals with, has the debtor ever been a party in any proceeding, administrative, judicial, on any environmental laws? Has the government, notified the debtor of any liabilities? And has the debtor notified the government of any releases? In addition, the forms make you disclose any properties that a debtor possess an imminent harm to public health and safety. And rather than everybody check that, they need to make sure they understand what imminent harm is, because the choice of that on the schedules may lead to significant ramifications, as we'll discuss going forward, about whether there is actually imminent harm from the property that they have. So you have to disclose a lot of things. And when you're filing for bankruptcy, you also have to consider, is it going to do me any good? Right? I've got this environmental issue, and how do I get out of it? And 28 USC 959 basically requires a debtor to comply with all existing laws. So this means a debtor doesn't have basically a free pass in a reorganization to avoid compliance with existing laws. They're going to have to address their ongoing pollution, and they're going to need to comply with the laws. There are cases where courts have actually refused to confirm plans where a debtor can't show that it can stop polluting. And therefore, because it's violating the laws, it can't go ahead and confirm. So if a debtor is required to clean something up pre-bankruptcy, it's likely it's going to be required to continue to do that post-bankruptcy, and we'll talk about that. So the takeaway of this is, you can't refuse to clean up, and you can't continue to pollute just because you file for bankruptcy. It's that old saying, bankruptcy is a shield, not a sword. So that's kind of one of the things. The other things you're going to want to consider, and you'll hear us talk about all these issues as we go forward, is the obligation that you're worried about going to be subject to the automatic stay, right? Is there an actual claim in bankruptcy? Does that type of environmental relief that the agency is seeking, does it even constitute a claim? Is it dischargeable? If it is a claim, when did the claim arise? Pre-petition or post-petition? Are there any fines and penalties? Can you abandon the property? Can you sell free and clear? In addition, you got to consider, who am I going to have to give notice to? If I want a discharge, I want to give notice to as many people as possible to make sure I get that discharge. So there's a lot of issues to consider. And even if you consider all these issues, and one of the most important things is, what's the best jurisdiction to file in? As we discussed earlier, courts are all over the place. So depending on what your issue is, you may want to file in one jurisdiction over another. And then, even if you've considered all these issues, it's not foolproof. I can tell you that. I recently filed a case thinking my fight would be with one governmental agency. Then the governmental bar date came and went, and another state filed a claim for $150 million. Now, this was in a subchapter 5 bankruptcy case. So all my best planning and everything in dealing with one state agency completely went out the door, and had to deal with another bigger issue that we were expecting was a $2 to $3 million liability. So even the best planning can't give you a foolproof way to get through bankruptcy. Turn it back to you, Mike.
Thank you. Laura, we started to touch on some of the environmental laws that are out there, or at least reference them slightly. Can we start with, one of the key laws that a debtor might have to contend with? What is CERCLA?
Absolutely. So CERCLA is a federal law. Sometimes it's colloquially referred to as Superfund, but it stands for the Comprehensive Environmental Response, Compensation, and Liability Act. It is really the main regime, I would say, for remediating contamination from historic pollution in the U.S. It was enacted in 1980, and then the Superfund program was established in 1986. There are about, I want to say, like 40,000 federal Superfund sites in the US. And under CERCLA, the EPA gets the job of identifying parties that are responsible for having polluted the environment with various hazardous substances. And then under CERCLA, the EPA can compel these potentially responsible parties, the PRPs, to either perform to clean up or to pay for cleanup actions. And I think it's really important to know that a PRP under CERCLA is broadly defined. So it can include, obviously, anyone who's currently owning the property or currently operating the property, but also former owners and operators of a property. If no responsible party can be identified, that's when Superfund, that trust fund, sort of kicks in to provide for cleanup. There's also two types of CERCLA response actions. So there's short-term, sort of quick responses that address immediate threats, like an oil spill. Then there's the sort of long-term, more comprehensive, what's called remedial actions that really are trying to permanently reduce or get rid of the risk of hazardous substance releases. So the longer term ones are often conducted at sites that are listed on the EPA's national priorities list. So a priority for cleanup. An example might be treating contaminated soil.
Thank you, Laura. Robert, why don't you continue with this and tell us about RCRA and potential state law issues that might come into play?
Sure. If you want to move the next slide. So RCRA is the Resource Conservation Recovery Act of 1976. It is more focused on making sure that waste is properly disposed of. And it does include a private remedy. So if the government isn't acting, private citizens can act. There are some similar state laws, and sometimes they go beyond what the federal law provides. And often you'll see a CERCLA and a RCRA action combined because there's both past contamination and also issues about whether the waste was properly disposed of in the first place. So often you see the two statutes asserted kind of alternatively or together.
Jeffrey, what is the Clean Water Act and how might that come into play in a bankruptcy case?
Yeah, so the Clean Water Act, again, federal law called the CWA, it was basically enacted to reduce the release of toxic materials into U.S. waterways. And it protects all waterways that basically have a significant nexus to navigable waters. It's very similar to RCRA, where the statute only has an injunctive mechanism and doesn't really allow the government to seek payments for cleanups. It's more of, again, injunctive relief. In addition, the statute can lead to fines and penalties for failing to comply for certain reporting requirements. And that can also lead to whether those penalties and fines can be non-dischargeable under Section 523A7. I will point people to the In-Re Exide Technology 613 BR 79, a district court case out of Delaware, in which it dealt with the 523A7 issue on a similar issue as the Clean Water Act, and it basically found that the penalties assessed against a corporation cannot be dischargeable. I mean, they can be dischargeable in bankruptcy, and they're not. They don't fall under the purview of 523A7. So while there are certain reporting requirements that you have to comply with, the failure to comply with them, again, may or may not lead to a non-dischargeable claim under 523A7.
And to close the loop on federal environmental law, Robert, what other environmental statutes should potential debtors be aware of?
I mean, there's a number listed on the slide here. They tend to be generally industry specific. So surface mining and reclamation is a big issue, especially in coal mines. And sometimes that's the biggest creditor in a coal mine. And even right now, coal is very challenged, including pricing, but sometimes people will keep it open because if it's closed, then that kind of will bring cleaning up the mine to the forefront versus putting it off for another day. And those numbers can be huge. So people want to put it off for another day. There is also the Federal Power Act, which is regulated by the FERC, which deals with wholesale power, including power from power plants, whether that's coal, natural gas, or other ones. And then there's a special act for nuclear plants, the Atomic Energy Act, and there's very strict regulations on how you can get rid of the spent fuel rods and the like. But again, those are generally specific to specific subsectors that operate.
Yeah, not just for potential debtors, I guess maybe even potential purchasers also need to be aware of some of these things. I dealt with a fraudulent transfer case once where reclamation of a mine at the end of its lifespan was an issue in terms of valuing how much the property was worth and what it should have sold for, and how to account for that question mark liability you have to put the mine back into its sort of pre-mining order based on environmental laws. So something to consider when you're out there purchasing potentially contaminated assets as well. Robert, just to stick with you for a moment and really wrapping this background law issue up, can you talk about environmental liability related to the cleanup of asbestos and how that might be managed in bankruptcy?
Yeah, I mean, starting with cases like Johns Manville, a lot of companies have addressed their asbestos liability in bankruptcy. And even though, products containing asbestos haven't been made for many decades, they're out there in the marketplace. They're in, arguably in brake pads and older buildings and the like. So, it's a problem that lingers on, even though it's generally not a product that's being sold anymore. And there's a special provision of the Bankruptcy Code 524G focused just on asbestos liabilities. And really, the goal is to establish a trust that covers both currently known injured people and generally future people that may discover they've been harmed by asbestos afterwards, who are represented by what's called a futures representative, to kind of look out for their interest. And the trust is generally supposed to be sufficient to cover the present claims and anticipated future claims. As we've seen from some of the cases, some people badly underestimated and the trusts ran out of money. But that is, the goal of these trusts. And generally, the debtor establishes the trust. Sometimes other people who might be liable, such as insurance companies with general liability policies or the like, may help fund the trust. And then generally, the trust is administered by a trustee. So which claims are valid, which claims are not, how much, a particular person's injury is worth, is generally dealt by these independent trustees and their firms that are very sophisticated on how you value an injury, whether it's, and there's questions about, do you have asbestosis now, or is it more you've had exposure to asbestos and you're expecting that you may develop asbestos in the future? So it's quite complex, but a number of these have been done successfully, and then the business is able to do what it's ever doing going forward. Cars, building products, are often companies that have asbestos liabilities.
So we've gotten a bit of a primer on environmental laws. We're going to switch focus now and talk about some bankruptcy concepts and how they might interact with environmental law. Jeffrey, for debtors in Chapter 11, can you talk to us about what an ordinary course transaction is and what kind of environmental work might fit in that scope?
Yeah, typically the Bankruptcy Code requires under 363 court approval for anything outside the ordinary course of business. So you don't need to approval for anything inside the ordinary course of business. And inside the ordinary course of business there's various tests, but basically I view it as, is this something that I normally did or a company in my shoes would have normally done prior to the bankruptcy? With respect to environmental liabilities, and by the way, if there's ever a question as to whether something's in the ordinary course of business, as a practical matter, the best thing to do is file a motion with the bankruptcy court to find out, because you don't want to be doing actions that aren't in the ordinary course of business and find out and deal with those issues later. So when in doubt, ask. But with respect to environmental, again, performing investigations under governmental orders that already exist or new orders would be ordinary course of business. Taking actions to prevent violations of laws. As we talked about earlier, you have to comply with existing law, so that's fine. Maintaining groundwater and other monitoring programs is going to be acceptable, along with continuing cleanup obligations under an injunction, where there's a court order requiring you to do that. Maintaining environmental insurance policies. That would also be ordinary course. Hiring consultants to perform environmental liabilities, also ordinary course. Now, if that consultant is a attorney, or if you need to hire an attorney, say you have a lawsuit already filed somewhere outside of the bankruptcy and you have counsel, debtor has counsel handling that separately, hiring professionals such as attorneys and accountants does need court approval and is usually not in the ordinary course of business. And entering into a new contract. That may or may not be in the ordinary course of business, depending on the size of the contract, if it's something you typically enter into, etc. So those are some of the considerations and some of the things that come up in environmental bankruptcy case that you should know.
Laura, can you talk to us about one of the most important concepts in bankruptcy and something we've mentioned a couple times already, the automatic stay?
Sure. So the automatic stay is found in Section 362A of the Bankruptcy Code, and it operates as a statutory injunction. And as its name suggests, it applies automatically once a bankruptcy case is commenced. The stay is a fundamental debtor protection in bankruptcy. It prevents creditors from racing to get to the debtor's assets. It ensures or helps ensure that creditor claims are dealt with inside the bankruptcy case in an orderly manner, we hope, and under the supervision of a bankruptcy judge. And the automatic stay is associated with the idea that the debtor gets a breathing spell or breathing space from its creditors. So anyone who is seeking to pursue an action that the stay prohibits must ask the bankruptcy court to lift the stay.
The automatic stay has become one of the longer code sections. Is there a number of exceptions and little nuances to it? Can you tell us about whether there are some important exceptions to the automatic stay in the environmental context?
Yes. So a very important exception is the exception for police power. That's in Section 362B4. As you say, the automatic stay section is quite a long section, but the police power exception is found early on in that list. So this exception allows a party to bring a claim against a debtor in spite of the automatic stay, so the stay doesn't apply, if that claimant is acting within a governmental unit or agency's police or regulatory powers. And I think the genesis for this exception, Congress was concerned that debtors might abuse the automatic stay by filing for bankruptcy and then sort of hiding under the stay, using the stay's protection to basically prevent the government from doing its work. So we don't want debtors to use the stay to frustrate sort of important governmental functions. I think an important thing to know about this exception is that government entities can't use it to collect a money judgment. The exception is for regulatory enforcement. I think in general, courts do tend to treat enforcement of environmental orders as falling within the scope of the police powers exception, but it can be unclear as to what exactly the government is doing in the environmental context. So it might not be clear whether the government is enforcing a regulatory order or trying to collect a money judgment. And so oftentimes courts will have to sort of tease that out. What exactly is the purpose behind what the government's doing here? This line will get blurry. We'll talk about this a little bit later, but particularly when it comes to things like environmental penalties and claims for environmental penalties, that sort of thing, you can sort of run into trouble or run into some confusion as to what exactly the government is doing. And so that's an important part of the police power exception. We're not trying to enable the government to sort of collect a money judgment. We are trying to, however, allow the government to do its job to enforce through its police power and regulatory power.
Fast forward through a bankruptcy case and just assume that we're in a Chapter 11. The goal of most debtors in a Chapter 11 case is to complete a plan of reorganization and get that confirmed. Robert, I'm going to turn to you. Can you walk us through, I'm going to say briefly because you could spend hours talking about plan confirmation process, but can you walk us through the plan process and highlight special issues that debtors facing environmental issues might face?
Sure. So there's a number of requirements to confirm a Chapter 11 plan. A Chapter 11 plan can provide that the existing business will reorganize under existing ownership, or the creditors kind of converting their debt into ownership, or it can provide for a sale within a plan. An important thing about a plan is that uh, impaired creditors have the right to vote on the plan, and parties in interest, which includes environmental authorities and PRPs, have a right to be heard on confirmation of the plan. The debtor gets an exclusive period for at least 120 days generally to confirm a plan, and plans with cases with environmental liabilities tend to be more complex. So it's often common that that gets extended, and that unlike so many quick bankruptcies these days, if you're really trying to address the environmental claims in the bankruptcy, it's going to take a while before you can emerge. Some things that may impact what you can or can't do with the environmental liabilities in the case is, is it for one of your factories that you still own? You can't emerge and continue to pollute afterwards, or necessarily even get out of, liabilities related to the site that you still own and operate. And operate could be you lease the site, but you're the one doing the operations that caused the pollution. Sometimes there's formerly owned sites where you owned it, but then you disposed of it, but under environmental laws, you may still be liable. And one question will be, is the environmental still ongoing there, or is it just a historical problem that's contained, but someone needs to pay to clean it up or to monitor it so it doesn't start leaking again? Um, Sometimes there'll be a non-owned third-party site, and a common situation of that would be a dump. So 100 different businesses in the area put various things in the dump, some of which are environmentally dangerous and leak into the dump. And that's where a situation where you get numerous PRPs. And, the question is, who put the most bad stuff in the dump, and who's responsible for what share of the cleanup. Sometimes there's existing orders, often called consent decrees, where the entity, before it files bankruptcy, has agreed to take certain actions. I'm gonna, do a retaining wall to make sure that the dredge doesn't leak. I'm gonna remove this old oil tank. Various things that you might be required to do. And as a general matter, certainly the environmental authorities will take the position you continue to have to do that during bankruptcy. Sometimes, if the order is just I have to pay for something that happened in the past that's no longer an ongoing liability, there might be some argument that that's really a monetary claim, even though it's in the form of a consent decree.
Jeffrey, under certain environmental law, liable parties may be able to negotiate a settlement. And I think Robert alluded to this too, that, during a Chapter 11 plan process, you might have continued negotiations. It might take a while to negotiate issues with all the parties that are involved. Can you walk us through that process of negotiating settlements with government agencies in the environmental sphere?
Yeah, sure can. And again, if a debtor owns contaminated property in a bankruptcy case, it only has a few options, right? It can keep the property and continue to clean it up. It can sell the property to a buyer who takes it subject to those liabilities. It could try to abandon the property, or it can negotiate a settlement. And what we're seeing more and more often is that the governmental agencies are willing to negotiate settlements. But the key is you need to bring the EPA and the state agencies to the table. And how do you bring them to the table in these cases? Well, you really have to convince them that a settlement makes sense, that basically show them that the debtor doesn't have the ability to pay and to clean up, and that they're going to do better off with a settlement than they would if they put the debtor out of business. So you need to find that leverage to bring them to the table. And that leverage could be, threatening an abandonment of the property or something like that. So once you get them to the table, a lot of these settlements recently have been done with the creation of environmental trusts. And what happens is there's a consensual transfer of the contaminated property to a trust or to the state, and the debtor no longer owns the property. The beneficiary of the trust is no longer the debtor. It's usually the governmental agency that you're being involved with. And this can be with multiple or individual sites. So if a debtor has, I think the first one of these I did, there were 7 sites across the country, and we dealt with multiple state agencies and the EPA, and reached separate agreements with each of them, how these transfer property was going to go there. And then can be really difficult to sometimes negotiate and take a lot of time to negotiate with a different number of players. But again, that takes time. And then, the key, if you ask me, is how are you going to fund these trusts? Because the EPA and these state agencies aren't going to agree to a settlement with just the debtor walking away and continuing to operate or sell its business. So how do you fund these trusts? And there's a lot of different ways to fund these trusts. One, you can use cash, right? Which could be an immediate payment from the debtor. It could be a payment over time. Sometimes lenders are willing to kick in a portion of their collateral in order to get a deal done to get the debtor out of bankruptcy. And sometimes for large cases, you can use a big proof of claim in the bankruptcy case if there's going to be a big distribution, depending on the timing, as another form of basically funds to do that. Insurance. A lot of these trusts are set up, and their main funding mechanism is a transfer of the debtor's environmental insurance to the trusts. And therefore, the trusts can make claims on the environmental insurance in addition to that. And sometimes you can also use existing financial insurances. A lot of these cases, debtors required to, prior to the bankruptcy, to give a letter of credit or a CD or something like that. So you can use that to fund it. But that's the key, is showing that there's money to fund that. And once you get that, I find that the states and EPA are usually willing to try to negotiate that. And one of the things you're going to have to negotiate is who's going to be the trustee of the bankruptcy case. And again, usually the governmental agencies are going to have final say in that, but you're going to want someone who's qualified, who's done this before, etc. The other things that you're going to want to negotiate is that basically the debtor is going to be relieved of its liabilities with respect to that property and those obligations. So you're typically going to try to negotiate a release, a covenant not to sue, and contribution protection under CERCLA, or under applicable state law. The covenant not to sue can actually be broader than CERCLA protection. So the covenant not to sue is the government saying, and if I'm the debtor, the government and the trust saying, we're not going to sue the debtor for anything related to this site anymore. So that's very important to make sure that you cover. And then getting contribution protection, which is also very important. And CERCLA, Section 1113F, provides for a person who's resolved its liability to the U.S. Or a state in a judicially approved settlement, that it should not be liable for claims for contribution regarding matters relating to the settlement. So it can give you protection from other PRPs and other entities who are seeking contribution. Typically, the court's going to approve the settlement and setting up of the trust, and it's going to give the trust and the trustee certain protections against third parties. Now that you can't do third-party releases, those protections are going to be a little narrower than they used to be, but they're still negotiated. And then lastly, the government or the state agencies are typically going to have to provide a public notice and a comment period to those who may be affected. This is really difficult to navigate in timing, right? You want to go ahead and push forward with your plan of reorganization, but they've got to give this. It's kind of a horse before the cart type of thing. But typically the state or EPA will start the process and it'll be finalized after confirmation. So you have confirmation. A condition of confirmation will be that the government provides the public notice period if it has expired and the government doesn't walk away. Typically, these agreements do give the government the ability to walk away after the public notice period, in case anything comes up during that public notice period. So little timing issues there. So that's been a really big thing lately, to do these environmental trust agreements, where, again, it's no longer the debtor's obligation on a go-forward basis. Typically, they're found in situations where the debtor is selling its assets to a third party, and they're going to remove these products. Not all the time. Sometimes, but very rarely is it done where the debtor itself is going to reorganize. The other thing is there's also, a lot of other unique ways to settle things out there. And there's a recent case not too long ago called Wellman Dynamics Corporation. And they were doing an asset sale, but you usually can't get rid of, the buyer usually can't take free and clear of all liens, claims, and encumbrances. And so Wellman was a specialized equipment manufacturer that did global aerospace products. And it operated a facility that was heavily contaminated, but it didn't have the money to clean it up. And it was a supplier to the U.S. military. So it was producing specialized castings for military helicopters. So it was critical. It was still needed. They wanted to sell it, but the problem was they couldn't sell it because no buyer could determine what the potential liability was going to be or what the agencies were going to look for in the future. So the debtor proposed kind of a unique way to go about this. They proposed a settlement that would require the buyer to just pay for future remediation based upon a predetermined formula tied to its revolving annual sales. If the business performed well, it would put in more money, and if it didn't perform well, it would put in less money. But ultimately, the deal was set up to where the buyer would agree to fund 3 trusts, one for an ongoing site investigation, one to fund a landfill closure, and one to fund investigations. And for the first 3 years after the buyer acquired the property, it would contribute, I think it was between like 0.2% and 2.5%. And within 5 years after that, it could go up to 5 years. But it limited the buyer's obligation to what it had to fund. So properties were put in a trust. The buyer only took on certain liabilities out of its cash flow. And this was an extremely unique way to settle with the government. Haven't seen that done. That's the only time I've really seen that done. But there are ways to work settlement agreements by being a little more creative. And again, the key is to make sure that the governmental agencies are getting more than they would if the case were to close down.
Anyone on the panel, really, can you maybe explain the mechanics a little bit more? If I'm a debtor that's filed and I want to negotiate a settlement agreement, I'm sure agencies have already, come in and made themselves known, and hopefully I provide a notice to whoever it is I need to. But who am I negotiating with? Who has authority on behalf of the government to negotiate those settlements? Is it a DOJ attorney in the environmental division that comes in? Is it someone within the EPA? Who am I negotiating with?
It's typically with someone from DOJ, and then they'll bring in somebody from the EPA to negotiate, and similar with the state agencies that are brought in as well. My experience recently, most of the environmental people in DOJ get it. They've been around for a while, and they understand what the issues are, but it's explaining to them, why it makes sense to resolve this. The government is pretty protective of certain things. One of those things is under RCRA, since it's only injunctive relief. They don't like doing settlements where RCRA is involved. Most of the cases that I've seen have CERCLA involved, and the difference between it is CERCLA, can become a claim in bankruptcy. RCRA might not be able to become a claim in bankruptcy. So in negotiation, it also depends on what the issues are with respect to that site.
I guess a 2025 gloss I'd put on that based on a few situations I'm seeing develop is, often you would have long-term people there or very knowledgeable people. With all the government layoffs and turnover, sometimes you have someone brand new to the situation, and that can really slow the decision-making process considerably. The other thing is you might have a tension between kind of the current federal EPA direction and maybe a very blue state EPA, where the state EPA, which would normally defer to the feds, may be much more active than the feds on a particular situation.
All very good points, and one of those reasons why in environmental cases, dealing with the governmental agencies, you may go well beyond that 120 days of a debtor's exclusive time period to file a plan. Let's go out of that process for a bit and talk about sales in bankruptcy. And Robert, I'll stay with you, jumping off on that last topic. How does the bankruptcy code allow a debtor to sell assets, and what particular issues arise in the environmental context?
Yeah, so I mean, Section 363s are very popular because you can do them much more quickly than a plan. There's no creditor voting on a 363, and certain requirements, like for instance, feasibility, aren't necessarily present in the same way in a 363. And it's also common, for the buyer to insist on as broad a language as he can get on free and clear, including findings that it's not a successor and that no one can pursue it under successor liability and the like. So for a buyer, traditionally 363, is a very attractive and quick way to do it. And as long as you can convince the judge to approve it, the sale will go through. Now, the environmental authorities, the PRPs, can show up and object, but if it's the highest value for the estate, generally those objections will be overruled, and it will go through. There are some issues. For instance, if I wanted as a buyer to say I'm immune from CERCLA going forward, even though I'm going to own and operate the same site, I probably can't get that finding. I could get a finding that I'm not liable for historical liabilities or maybe off-site landowners, but I don't get a get out of jail free card for going forward, in that kind of provision. And if the buyer was also, for instance, an insider, let's say the officers are buying it and they also maybe have potential officer and director liability for the past contamination, there'll be some real issues, especially with the limiting of third-party releases, as Jeff mentioned, whether they can kind of get immunity for their involvement in the past contamination. So, it can be attractive, it can be broader, especially for historical liabilities, but for ongoing issues, it's not a panacea.
Important for all parties to pay attention when a sale occurs in this context. I had a case I was involved in where the previous owner was monitoring a case and had some interest in it. The property was going to be sold. They were very concerned because they had done a bunch of remediation on the property. They had remediated the soil up to a certain depth as required under consent decree that they had entered into. They were concerned that a future owner might do something to disturb that, to develop and disturb the soil or the site in a way that they would have to remediate to a lower depth. And so wanted to make sure that they were protected and had to insert itself into that situation. So again, if you are one of those auxiliary parties on the outside that has an interest, you want to be aware of what's going on in the bankruptcy case. Go ahead, Jeff.
Yeah, can I, Bob, are there situations where, if you're buying a business that in part of that business is a property, there are companies that'll come in there that'll buy that property and kind of clean it up and take the risk themselves?
There are, and in fact, those businesses guess, sometimes that like the debtor or the PRPs pay them to take it on, and they are betting that they can manage and clean it up cheaper than than the debtor itself could. And sometimes you can do something where there's a sale leaseback. So one of these environmental remediation companies will buy the property, but then they'll lease it back to the operator for purposes of operating, say, the factory, but they'll handle the cleanup themselves. Or often it's not so much the cleanup as containing, making sure the contaminated pools or the remain contained and don't go outside their their clay linings, that kind of thing.
What if I can't sell a property in bankruptcy? It's worthless. I can't get anyone to buy it and clean it up. I can't afford to clean up. In bankruptcy, if I'm a typical debtor, if I have an asset that's not worth anything, I can just ask to abandon it and it just leaves the bankruptcy estate. Robert, can I do that in this context? Can I just abandon an environmentally contaminated piece of property?
I've done it. It's not as easy, because there is the real question is, how vital is it to the reorganization or the sale that you abandon it? If you're just trying to get rid of a liability that, you otherwise should be stuck with, that may not fly. But there are cases where you can say, this particular property, maybe it's a former site, maybe it's an adjacent piece of land that's not where the factory is not vital. And then the question is, who do you abandon it to? And you typically would abandon it to the state where it is. And of course, the state authorities generally don't want to take on these properties, especially when they have no one to pay for it. So, typically the states will litigate and say, no, this abandonment is not key to this business emerging, and you should not allow them to dump this on me. And it really depends on your judge and your facts, how compelling that is.
So a slightly different concept, Laura. We discussed one of the goals of bankruptcy being give a debtor a fresh start. And an important part of that fresh start is a discharge in bankruptcy. Can you discuss the concept of discharge and then subsequently whether environmental claims can be discharged?
Sure. So, as you mentioned, the discharge is an important part of what gives the debtor that economic fresh start. And it can be a key reason the debtors file for bankruptcy, because if a debt is discharged, the debtor does not have to pay it and creditors cannot collect debts that are discharged. So it can be a key benefit. In terms of whether environmental claims or liabilities can be discharged, it really depends. I think there's a couple of different components here. So one is a timing component, because only pre-bankruptcy claims are dealt with in a bankruptcy case. So normally you wouldn't discharge a claim arising after the bankruptcy case has been filed. I have mentioned this before, and I think a couple of other folks have as well, especially in the case of environmental claims. It can be difficult to fix the time when a claim arose for purposes of bankruptcy. So if a claim is clearly something that's historical, it's arisen in the past, sure, that's something that can be in general discharged. It's harder to get rid of a claim that's ongoing, that has spanned a long period of time, maybe continues on into the bankruptcy case, or certainly a future claim that's going to happen, after the bankruptcy has been filed. So there's a timing element that affects dischargeability. The other thing that I think is important is that the term claim itself is a defined term in the bankruptcy code. So the term claim, and I'm paraphrasing, sort of picking and choosing from the bankruptcy code's definition of claim, which is quite extensive. A claim includes, or to have a claim, a creditor must have a right to payment. That term, right to payment, has a broad definition or connotation. So Congress included in the definition of claim the right to an equitable remedy for breach of performance if such breach gives rise to a right to payment. So that means that the holder of an equitable remedy against the debtor, like somebody who has a right of specific performance or an injunction, which is important for our context, may also have a bankruptcy claim, and only claims may be discharged. So this problem comes up a lot, or I think a fair amount, in environmental cases, because the question is, can the debtor escape a cleanup injunction by basically saying, well, that injunction is actually a bankruptcy claim that can be discharged? So there's a very famous Supreme Court case called Ohio versus Kovacs from 1985. And in that case, the court said an individual's cleanup obligation is a dischargeable bankruptcy claim. I think, though, actually, and the practitioners on this call can correct me if I'm wrong, I think it's actually more common, though, for environmental cleanup obligations to be found not to be a claim and therefore not subject to discharge. So even though we have this Kovacs decision from the Supreme Court, there are a number of different cases, and some of them are on the slides, where the courts say, actually, you know what, this is not a claim, it's a non-monetary obligation. And so that claim can't be discharged in the bankruptcy.
Jeffrey, can you just continue on the issue of claims? If a debtor shares liability on environmental claims with another party, what recourse might it have in bankruptcy?
Yeah, so it's well settled that pre-petition monetary judgments is a claim that is dischargeable. So those claims, the parties are going to have to, on the other side, are going to have to file proofs of claims, and they're generally going to amount to unsecured claims. The question arises to whether it's a claim for contribution or reimbursement, because under Section 502 of the Bankruptcy Code, if the government or a PRP group files a proof of claim, where, for instance, a PRP group wants contribution, the debtor can object under 502 and to disallow the claim for reimbursement or contribution. And so what 502 is set up to do, it's set up to protect the bankruptcy estate against the risk of double payments of claims. Without it, a debtor could be liable to the primary creditor, and it could be as well as other parties seeking contribution. So in the environmental context, 502 is a very important section and allows the debtor to wipe out those claims. Now, the claims have to be contingent. The debtor has to be co-liable, and there has to be a right to reimbursement or contribution. Now, most courts find that an environmental remediation contribution claim is contingent if the claim has not actually, if the claimant has not actually spent the money for the cleanup. So that's the first step, and then there's issues that you'll get into as to whether there's co-liability, whether or not there actually is co-liability, and whether or not there's a right to reimbursement or contribution. So it's a good way for a debtor to knock out pre-petition claims in order to try to help get his plan confirmed.
just about out of time, but real quickly, can you tell us what happens when regulatory agencies have penalty claims against responsible parties? How are those treated in bankruptcies?
I mean, penalty claims are generally often either not allowed or subordinated because they are otherwise impacting what other creditors get, and the goal is not to not to dilute the other creditors with a penalty claim. And sometimes it's not even the same ownership that you're trying to penalize for past bad acts that are being penalized, so that the purpose of the penalty may not, in the eye of the bankruptcy judge, may not be as applicable because whoever the bad actor was may have been former management, for instance.
Anything to add on that?
Sorry, did you say me?
Yes, Laura, sorry.
Oh yeah, sorry. So real quick. So if obviously if they're pre-petition claims, they aren't entitled to priority. It gets a little bit more interesting when what happens with post-petition penalty claims. So if the so-called penalty is actually compensatory in nature, if it's really supposed to compensate for cleanup costs, that can be an administrative expense. So the Third Circuit has held that costs incurred by the state in contracting for cleanup or administrative expenses because they were actual necessary costs and expenses of preserving the estate. If the penalty is not compensatory in nature, it's a true penalty, the courts are divided. So the Third Circuit has said that, if this is a true penalty, no administrative expense priority. But the First Circuit has said, well, actually, these claims, even pure penalty claims, can get treated as administrative expenses because of that requirement that we mentioned earlier, 28 U.S. Code 959. Debtors in possession and trustees must comply with state environmental laws. So the First Circuit has taken a different view. In the 11th Circuit, the court held that non-compensatory penalties that were assessed against a debtor as punishment for environmental violations were administrative expenses, but only to the extent that they were incurred as consequences of operating the debtor's business. And so the court sort of expanded on this and said, look, even though the penalties in question won't be used to remediate, giving those penalties priority status serves that federal policy that's articulated in 28 U.S. Code Section 959 of requiring our debtors in possession and our trustees to operate the estate in compliance with state law. So the courts are a little bit all over the place, but those are kind of the issues that they're thinking about.
We are effectively out of time, but I think there's one topic that I think needs at least 30 seconds. Robert, if you could do this in a very short time, can you just walk us through some due process concerns and notice concerns in this area?
I mean, generally to get free and clear, to get a discharge, you're supposed to give actual notice if you know who it is to adjacent landowners, former employees. If you don't give them notice, then there's some real due process issues whether you can discharge them. Sometimes you don't know everyone, so they'll also do like a publication notice in the local paper for anyone that they don't have actual current addresses for. But to the maximum extent you can give actual notice to discharge, that's going to be much more likely that it's enforceable down the road. And sometimes the bankruptcy case is closed well after this, after the claim arises. And so, it'll be a real issue on, is the claimant who arises 5 years later, for instance, somebody who developed cancer, did they get notice such that the discharge is effective?
Well, it's been a lot to go through. I think if we can sum everything up in one, in sort of a short conclusion, this is a very complex area. There's an alphabet soup of government agencies out there that might potentially be involved. We may have an extensive negotiation process with government agencies. We have a lot of due process and noticing concerns. So if you have a debtor entity that has environmental issues, it takes a lot of planning. Consult your local bankruptcy attorney that's knowledgeable on these issues, and take the time to understand what circuit you're in, what the law is in your particular circuit, and everything that, just all these that we've briefly touched on requires extensive planning when you're dealing with a debtor with environmental issues. I haven't seen any questions come across, and we are actually a couple minutes over time. I'd like to thank all three of our panelists today for their time, for sharing their knowledge. Thank you to Financial Poise for hosting this webinar. There'll be an article coming out, and this video will be available in reproduction after today. Once again, thank you, everybody. Goodbye, everyone.